Gantoos on his continuing journey of discovery into life's challenges, opportunities, options, and all the latest and greatest things that come with getting older. The Raad Life is brought to you this week by Your Home for a Lifetime, a company dedicated to empowering you to stay safely, independently, and comfortably in your own home. And now here is your host, Rod Gantoos.
What is happening, Orange County? It's another year. We took January off. We are back. This is our 5th year, Paul.
Oh, amazing.
5th year.
They said it wouldn't last.
You know, I thought that they might actually get you to leave the building, ask you to, evict you because of the kind of company that you keep in this room, but I guess not, huh?
No, they haven't caught on yet.
They haven't caught on? Thank God. So welcome, everybody. It's another year, 2020.
It's another decade.
It's another decade. Last time we were on here, we did the last show of the last decade.
Yes, right.
Right? And after 5 years, I figured I deserved a month off. So I took a month off.
1 month.
Right. Plus, of which, of course, life happens when you make plans, right? I thought I was going to have a month off. I ended up getting hit with this friggin' influenza type A+, which, as my doctor said, I'm an overachiever. That's why I got an A+ instead of an A. But basically, it knocked me out for about 2 weeks. So
I had that last year.
Thoughts and prayers, as they say, for anybody out there who's suffering under this year's flu epidemic. But we wanted to kick off the year with something relevant to the beginning of 2020. And there's a lot of stuff going on. And I really don't want to delve into the same stuff. We usually get to politics at some point in the year, so let's not start there, right?
Well, the year started. That's all politics is.
Yeah, I know. But I'm kind of like, to be honest with you, I don't know about you, but I'm kind of tired. I'm kind of like a little sick and tired of just that, politics, decrepit corruption bullshit on both sides of the fence from everybody already, and it's only February, right?
I don't think you're alone in that one. I was stunned over the last few weeks. Very few people wanted.
And can I just say something? And people know that this show is basically, nonpartisan. I am a non-party affiliated, right? So we basically are equal opportunity grillers all across the board, right?
Yes.
But people know that I am not going to spare anybody if I see something, right? What the heck is with the friggin' app in Iowa? Okay, what the hell, man? We've had Facebook for over a decade. Okay, we've been on the internet for God knows maybe 20 years, right? That's 94 at least that I remember.
They couldn't
the days of
figure it
AOL and $1 a minute, right? On a free CD for 10 hours. What the hell, dude?
But did you read the story?
How can you expect? And I'm not picking on the Democrats, but can you expect whoever it is to send an impression that you can run a country if you can't freaking get a friggin' caucus with one app to work?
But again, like politicians do on both sides, they pick somebody they knew, and that company had never built an app before. They did a texting app, but they had never built an app. But they had the connection.
So they should have gone to the Valley and got somebody who did a sexting app. They may have been better at it, right?
Right.
Than a texting app.
Right.
Yeah, well, you know what? As they say, politics makes for strange bedfellows, right? No, it's just I just need to get that out of my system. I could not believe that. I'm like, seriously, people, right? With that being said, we don't want to talk about politics at the beginning of this year.
No.
So I want to talk about something very relevant, something that actually affects me, affects a lot of people that I know. And to be honest, I'll be the first to say, I'm as confused as hell about this thing as most people out there.
I really am.
Right? But everybody's like running around scared of this. Like they're really concerned, and they've kind of known it was going to be coming, and it kicked in at the beginning of this year, and that is California State Law AB5. And that is something that you can't go get a cream for at the doctor to basically cure yourself. You got to educate yourself with this. So we're starting off the year with something that kicked in at the beginning of this year, and my guest today is a good friend of mine and a person that is absolutely the right person to talk about this thing. He's actually been asked to do this already a couple of times, and I figured I better get on his schedule before he gets too busy doing this. And he has other actually engagements lined up that we'll share with you guys. But I'd like to say hello to Mr. Lee Goldberg. Hi, Lee.
Hey, Rod. How are you today?
I'm good.
And is he a lawyer? You never have lawyers on the show.
He is. Well, he's a friend first and a lawyer second. But yes, he is very much a very accomplished and very sought after attorney. And I'll let him basically introduce a little bit of his credentials in that capacity. But yeah, this thing is something I've heard of probably for at least 6 months, maybe a little longer, that it was coming. I heard everything from the fact that, the sky is falling, that, if you're an independent contractor or freelance, or you happen to try to offset your fixed costs by engaging with contractors, contract employees, or not employees, contract labor, based on as a need basis, those days are over. You got to shut down. I'm sure I'm not the only one.
There are media sites that are laying off freelancers from California because they don't know how to handle this.
Well, that's right. They are laying people off, and they don't have to because it's not like that.
So, Lee, am I
Well, tell us what it is first.
Am I saying this correctly? In that the fact there's a lot of people out there that are just like really don't have enough information and they're running scared.
Yeah. Well, that is the natural reaction whenever, as human beings, we face a change. The first thing we do is panic.
Yeah.
Okay.
Well, before we panic, tell us for the 5 people that don't know what we're talking about, what is AB5?
Run! The sky is falling.
We're good. Listen.
So what is AB5?
So let me tell you what AB5 is. AB5, Assembly Bill 5, was actually, and frankly, I'm not sure why everybody still calls it AB5. It's actually been codified into the Labor Code as New Labor Code Section 2750.3. And what that section does is it changes how we categorize an employee versus an independent contractor. And some people call them 1099 contractors, ICs. As we talk today, I'll use all of those terms interchangeably. Right. It all means the same thing.
So it's not ending independent contractors. It's defining legally independent contractors versus employees.
That's correct.
Okay.
I mean, obviously, having an employee gives you all sorts of obligations under the Labor Code.
Right.
Independent contractors, not so much. You could pretty much, my goodness, if you want to pay your independent contractor with old furniture from your house, God bless.
Right.
So, yes,
and this is
now. Was there something in the code or were there any definitions prior to this?
Yeah, here's what happened. In 1989, we had a California Supreme Court case by the name of Borrello.
Okay.
And Borrello set the standard for the next 30 years.
Okay.
All right. And what that standard basically was pretty simple. All right. You needed to have a written contract with your 1099 contractors. And by the way, I will tell you that probably about 80% of the people out there don't understand that. Right. They do not know that they are in violation technically if you don't have a written contract with your 1099 contractor. Which is
very common.
Simple.
Yeah.
I didn't know that. I thought it was just gave you a test of whether or not you could consider that person an independent contractor. Did you have control? What were there were like 3 or 4 tests that you were supposed to...
Actually, there's a whole lot more than 3 or 4 tests. But the Borrello decision basically said it is a culmination of all the indicia of what you have there, and they named something like 25 or 26 separate indicia of an independent contractor, and their ruling was basically it will be the totality of the circumstances.
Okay.
We'll evaluate some indicia more important than other indicia. Of course, the indicia that was just mentioned, that they have independence in rendering that service, that they're not overseen. That's one of the more important indicia. However, there were about 25 or 26 indicia, and what lawyers did in order to help their clients, they gave them all written contracts, and those written contracts addressed many, many, many of those indicia. To give you an example, my independent contractor contracts that I've used for 30 years address anywhere between 19 and 22 or 23 of those indicia, because I'm not about to have some smart aleck administrator or judge tell me I had one indicia too few.
Yeah.
Right?
Yeah.
But that form of agreement under the old laws we can use for almost any type of independent contractor because all the indicia were the same. Okay. Well, now things have changed. There's a new sheriff in town. and they have changed the whole way we look at this.
And did this
what initiated the change?
Was it the Dynamex case?
Yes. Look, we talk about the law AB5 commencing January 1st of this year.
Yeah.
However, the Dynamex case came down, and that was a unanimous Supreme Court case. Okay. And frankly, lawyers are all taught in law school that bad facts make bad law. So in April of 2018, by the way, this law has been in effect since April of 2018, not January 1st of 2020. Only the Labor Code section is in effect, which adopted the Dynamex ruling. However, I happen to believe that the Dynamex ruling came down because of bad facts make bad law. And here's why. The Dynamex ruling was a unanimous Supreme Court ruling that changed the entire face of the law. Okay. Number one, we don't have very many Supreme Court rulings that changes long-standing law for 30 years on a dime. Mm-hmm. It doesn't always happen. And we certainly don't have it happen in a unanimous decision. Yeah. The reason why this happened is because, let me go a little bit over Dynamex. In the Dynamex case, essentially, it was an online food delivery service. Okay. All right? And that online food delivery service had all of its drivers as employees already. They did withholding, they paid Social Security, they even paid mileage, they had benefits for their drivers, they were all employees. Well, a new CEO comes into town, and as new CEOs will, they have to make their mark. Yeah. And this CEO brags about increasing profitability by cutting costs. And what did he do to do that? He fired every one of those drivers, took away all of their benefits, took away their mileage, turned them into independent contractors, then bragged to his shareholders that he saved like $1 million, $1.6 million in doing that. Right. Well, that did not sit well with the justices of the California Supreme Court. Right. You're showing them that we did use them as employees, and now, because for a money-saving thing, we're not going to give our employees benefits, and we're going to change them all into independent contractors.
Which is actually something that I've heard over the years a lot of people do. So
you can do it if you can get away with it.
No, my point is, this is not something necessarily that's unique to that company. It's been happening. It's just that this guy basically happened to be where it's like, well, hold on a second, Pard. Okay. And so when was that decision?
That decision was in April of 2018.
Okay, so a couple of years ago.
Yes.
Okay.
And so the Dynamex decision essentially only addresses what we're going to talk about later on as the ABC test. Okay. The only reason we have the exceptions for the various professions is because of the new Labor Code section 2750.3. In other words, the Dynamex law says you either satisfy the ABC test or you are an employee, period, end of story.
Except if you've got enough lobbying power and you can get a carve-out in the new law for your industry.
That's correct, but that is not in the Dynamex decision itself.
So what is the ABCs that were in the decision?
The ABC test is like any other three-prong test in the law. Okay. There's nothing special, nothing magical about it. Okay. All right? But here's what the law says. I have to talk about the law. Sure. Understand 2750.3 is your typical lawyer's full employment statute, meaning you got to be a lawyer to understand it and read it and get through it. Okay. But basically it's a half a page of law. Yeah. And 12 pages of exceptions, just like you had said.
Well said, yeah.
All right? 12 pages of lobbying efforts. All right, so the basic law is this, and here's the biggest change in the law that nobody talks about, and that is the burden of proof. Okay. Because remember I told you under the old law, as soon as we had our contracts that hit all of those issues, then all of a sudden, that's a prima facie case. So then all of a sudden, the EDD or the FTB or workers' comp or whomever it is has to prove that you didn't act that way.
Right.
Well, the biggest change in the new law is the burden of proof, I believe. Nobody seems to be talking about it. Everyone wants to talk about the ABC test.
Switch the burden of proof to the other side.
That's right. Now, the hiring party
has the burden of proof.
That's right. It is by law. a presumption, an automatic presumption. It's a rebuttable presumption, but it's an automatic presumption that you have an employee. You do not have no such thing as a 1099 contractor.
That's your starting point.
That's their starting point. When they walk in the door for the audit, every single one of your 1099 contractors are employees as far as they're
unless
concerned.
Otherwise proven.
Unless the hiring party proves three things, which is the ABC test.
Okay.
Let's talk about the ABC test.
Okay.
The first part of the ABC test is actually, I think, the simplest part of the ABC test, and that is the independence, the freedom from control and supervision of the hiring entity. Let me give you two examples of the two ends of the spectrum. Mm-hmm. If you're one of those companies that sends out a project, you give them a deadline and milestones to accomplish, and the project comes back and you use that project and integrate it with all of your other stuff for your clients, you satisfy prong A. That's independence. If you're going to have your independent contractor come in every day from set hours to set hours, you're going to stand over his or her shoulder, tell them how to do the work. You're going to have milestones that they have to accomplish on a daily basis or quotas for them. You're probably going to fail part A of the test, okay? It's got to be true independence. And the important part, again, another change from the law before, not only do you have to prove the independence under the contract itself, we still need a written contract. Not only do you have to prove the part under the contract itself, but you have to prove that it operated in that way. Okay. Now, I got to tell you something. I have no idea how anybody proves that a contract 4 years after they're questioning it, that it operated a certain way.
Well, the only way you can do that is by basically asking the person who was delivering the service. I mean, that's the only...
Right.
But that's assuming...
And what if they lie or they exaggerate or they...
But that's my point, is that's assuming that the person who's basically being asked the question is going to do something that's actually in counter to their own best interest.
Well, I got to tell you something.
Unless there's some issue between the relationship between... Yeah.
If you have good counsel...
Yeah.
Good counsel is going to make sure that all those representations and warranties are in there, that there's an indemnity for a breach of those representations and warranties.
Right.
And if that 1099 contractor, if you have the right contract with them, if that 1099 contractor all of a sudden wants to make a workers' comp claim, claiming as an employee or she's an employee, or wants to make a labor claim or any other claim or doesn't want to support you in your audit,
right.
If you have the right contracts, you can make that person's life rather uncomfortable.
Now let me give you a tough one. We've had 2 or 3 lawyers come in. One lawyer said, like you, it's overblown, the fear. One said, no, this is the sky's falling. This is going to change everything. And here was their extreme case. And I knew you were going to laugh when I say this because I did, but might be. So in that control test, that A test, that first one, let's say I have a landscaper. I have a guy who cuts my grass. And I come out and tell him, I need it cut every Tuesday because it's the only time I can be here, or I want it every Monday done. And I want to make sure you cut the bush over here, and I want you to trim this part over here, and I want to make sure you get that done, rather than letting him use his own judgment how the lawn should be cut. Am I now controlling him? Has he now become my employee?
Let me first point out that it would never be an employee because that person is rendering a service to you. They are not working for you in your business. So that's first of all. So let's start it that way. Okay. All right. Second of all, those minor kinds of details are what I call milestones and parameters and scope of the work.
Right.
You're allowed to give parameters and scope of the work. You can't stand over that if that were an employee as opposed to your gardener. But if you can't stand over that employee and say, you will punch your time clock at 9 o'clock to get this done, and you will leave by 11 o'clock, and I'm not going to pay you for any moment over that, and I'm going to pay you hourly, and by the way, you must use my tools to do this work done. You can't bring your own mowers and such, and there's obviously levels of control.
But if you, to use Paul's example, if you actually tell that landscaper the scope of work that you are being contracted to do includes these parameters or benchmarks, and then they basically and that there is a timeline or a deliverable date on there, then that is exactly what Paul just mentioned, but I articulated differently.
Yes.
Basically, and in that case, it is a contract with a defined scope of work and a defined end deliverable, and then you just get out of the way and let them do it, and that is how you address that. Paul.
So this lawyer's fear was that crafty lawyers, though, are going to be crafty and are going to interpret what I just said. Maybe I said it the wrong way, maybe you said it the right way, but that this is going to open up a flood of litigation.
Well, I do see a flood of litigation, but I do not see it in Part A. I see it in Part B, frankly.
Well, plus, Paul, what you to Lee's point, the way I understand this, and I may be completely wrong, is it's got to be it's a situation where you would actually have to be a landscaper yourself, hiring a landscaper where there's a replication of the basic business that you are in. Well, but as a homeowner.
Yeah, but you could be, for example, you could be, all right, so I have a campus over here, a big building, and I have my landscaper clean the grounds for our company here. So again, if I tell him he's got to do it on Monday, he's got
Are you in the landscaping business?
No, it doesn't matter. He's right. If he hires a landscaper and the landscaper does not qualify for his business, and the landscaper does not qualify under the ABC test or an exception, yes, that landscaper should be an employee, but that will never happen for a landscaper rendering services for a business for a whole lot of reasons.
Okay.
For a whole lot of reasons, that landscaper rendering services for a commercial building most probably satisfies the entire ABC test.
So let's move on to the B.
Okay. B is where I think we're going to have a lot of litigation. And B basically says that this independent contractor, this 1099 contractor, performs work for the company that is outside of its usual course of business. Now, let me give you examples of what that would be. If I own a property like Paul just
I own a radio station.
Right.
Yeah.
If I own a commercial property and I'm hiring this landscaper, my business is to rent space in the property. That is my business. Keeping it looking nice is administration of my business, but my rent is the business. And that's the way I would look at it.
It's not the core business.
That's not the core business.
Right.
To give you an example, if you have an outside HR person, if you have a fractional CFO, if you have a fractional bookkeeper, all of those things are administrative processes. Now, where it gets a little tighter and a little more interesting is what happens when you have an outside salesperson to sell your business product. Is that part of your core business, or is the manufacturer of the product part of your core business? So it gets a little tighter as you get a little closer. And that's why, by the way, I gave you examples on the two far ends of prong A.
Right.
I will give you an example on the two far ends of prong B too, because there's all sorts of gradations in between. All right. So to give you an example of something that is in the normal, usual, and ordinary course of business, and that is if you are a consulting company, let's say, and you are hiring a consultant to render services to your client, and they render the services directly to the client that the client is paying for, that fails Part B, because they are delivering. That contractor is delivering to your client the service that your company charges for and renders.
What if they're providing that as part of what you would deliver to your client, but they're delivering to you?
Well, it doesn't really matter. Okay.
What if it's a regional thing? I need a consultant in Florida, and I'm based in California, and so I hire somebody we got the contract. I can't go to Florida, so I hire a subcontractor to handle it there. He just wants to come in and work on this one gig, and I'll share the profit with him here. But you're saying, but we're offering the same service.
But wait a minute. You just changed the entire parameter
of course, right.
by saying that this person's in Florida.
Right.
Florida laws apply to someone rendering services in Florida, not California law.
Okay, all right.
Okay? So if any company that is a non-California company that's hiring California employees, they must follow California labor law. I don't care if they're from Alabama.
Right.
Okay? Same thing if you're from California and you have employees in Nevada. Nevada law is going to govern your employees, just the way it's going to work.
So that's one end of the spectrum for Part B.
Right. Here's the other end of the spectrum for Part B that is foreshore, administration, a bookkeeper. You're hiring a bookkeeper.
Yeah.
Part B is satisfied. They're not rendering the service to your client. They're not providing the service that is in the usual course and scope of your business. So you satisfy Part B if they are rendering a service for the administration of your business.
So let me give you the example. I'm in the media business, and I've read about the number of, you're an online magazine. You write news. You cover some story. You write stories. And you're based in Michigan or whatever here. And you regularly have freelancers because you don't have staff anymore. You're a cheap online media company here. You have no staff. So all your stories are written by freelancers. And freelance writers have been around for 1 million years, wrote stories for every major publication. They usually supplemented what the staff didn't do. Now there is no staff, so they're writing all this stuff. Many of these media companies are saying, I'm not going to hire anybody in California. Forget it. We're going to hire only freelancers in other parts of the state that don't have this because they are providing the same service that we're doing, and California would probably consider them employees. And we don't want them. We not only do not want to pay them and give them benefits, we have to get them to take lunches and all this other stuff. They're out of our control. We can't see where they're at.
Well, actually, Paul, I will tell you, you would be right if there weren't an exception for a freelance writer.
Exactly, which is why there are, yeah.
Okay. You would have an issue there. They would not hire independent contractors out of California, but there's an express exemption for a freelance writer. You have to meet several criteria in order to meet that exception, and one of those criteria is that freelance writer cannot have more than 35 submissions in any 1 year.
Yes, right. I saw that.
Okay. So there are exceptions. There should be many, many more exceptions. Let me talk to you about silly stuff that's in there. Believe me, everybody knows this. Every one of these exceptions are really a function of lobbying efforts.
Well, we'll go to the exceptions in a minute, but so that's Part B.
That's Part B.
What's Part C?
Part C in the last part, remember, you have to meet all three of these,
Yeah.
all right? So if you fail any one of these, you fail the ABC test.
Yeah.
All right. And you have an employee. So Part C, again, I think should be fairly easy, and it's something we could also manufacture. And that is that the independent contractor that you have engaged is involved in that business rendering those services for other people. Period. What I like to do to prove that up and shore that up, I've done everything from attaching a copy of their articles of organization, which, by the way, is not the be-all, end-all. I put a copy of their homepage of their website with all their advertising, their business cards. In one circumstance, what I had them do was write out their client list, put it in a sealed envelope where their initials or their signature was over the seal, put it attached to the agreement, and the agreement provided that it may not be opened unless a court orders it opened upon a challenge as to whether this person has other clients, because that's one of the requirements in some of these.
So if they have other clients which they're providing similar service that they're providing to you, they are basically not an employee because they're not exclusive to you.
That's right.
All right.
What this does, to give you an example, I was going to give you an example of what will not make it.
Yeah.
While there may be a question as to whether outside salespeople satisfy B, I will tell you if they are captive outside salespeople, meaning they don't work for anybody else, you will fail Part C, and then you will not satisfy the ABC test. You will have an employee.
And most sales organizations I was familiar with in recent past, they had outside sales reps who probably only handled that product and maybe one more.
Well, maybe one more works fine.
Right.
But I will tell you, if they are the sole rep, I mean, the sole company that they rep is your company. you might have some problems
Won't they just
under
create
AB5.
fake things, though, where 99% of their income comes from their one rep presentation to this one company, and then they get 1% or a half a percent from somebody else?
Is there
just
anything like weighted that also has to be met?
It's really funny you ask that question. That's really an insightful question, actually, because
he has his
I
moments.
specialize in these. Yeah.
He has his moments. Yeah.
that's a very insightful question. Because here's the deal: every one of these exceptions, most of these exceptions, I will say, have requirements you have to satisfy in order to be able to use that
The exception,
exception.
yeah.
Right. Sometimes one of the requirements is written in a manner that says you have to hold yourself out and advertise yourself to do this work for other people. Hold yourself out as a business. It says nothing about having other clients in that business. In the B2B exception, and in fact, specifically in the contractor exception, it doesn't say you have to hold your out. It says you have to have other clients. Neither of those things say what percentage of clients you have to have.
Right.
Now, I have heard some misinformation out there that people think that 25% or more, or at least 25% or 35% has to come from some other source in the business you have. That
There's
is
no- there's
not
nothing
in the
in
code
there.
section.
Right.
So I don't know where that comes
Okay,
from.
so before we go get into the exceptions, Paul, let's give the number out. If anybody has questions, I'm sure people do. If they're listening, they want to call in and ask Lee any clarifications.
949-330-7761. That number again, 949-330-7761. Operators standing by. I'm going to tell you, most people are just sticking their head in the sand. They're either hoping this is not going to play out, it's not going to hit them, I'm too small, I'm not going to get it.
Well, better to find out than to basically be in an unknown, because the stress alone will probably drive you nuts. So definitely take advantage of this opportunity. What I'm also going to do is, we're not going to cover everything in this 1 hour. I mean, we're almost at the time here. I'm going to basically also put out some of this information in sections over the course of the next few weeks that Lee has been gracious enough to offer to put it out. We'll put it out on the Facebook page. We might even send out an email blast also and connect you with Lee. But really, this is something, I mean, I know for me, for my business, this is something you need to educate yourself about. Otherwise, you're going to be caught literally with your pants down. And it is, like any law, I would assume, is something that is, the ink hasn't dried. It's going to have to go through trial and error and testing. And,
Heavy emphasis on the word trial.
Right,
Yeah.
right. And that's how it's going to basically be weeded through. But already there's exemptions, there's already cases, there's already stays, there's all this stuff. So really, do yourself a favor. If you are a sole proprietor or an S corp, you got not a lot of employees, you're operating on contract basis, educate yourself on this. It's very critical.
I'll tell you one other reason too is that it's already being because California seems to lead the law in writing, lead the nation in writing laws. I'm heard that it's also being considered in New York and other places like that where they're going to copy what we've done.
Go ahead, Lee.
Let me just tell you. Number one, it's being considered in 8 other states right now. Right now, I think it's this weekend or next weekend, there's a symposium in Washington, D.C. about California's AB5.
Right.
That's first of all.
Sorry, Lee. Before because I don't want to miss out on this. You also have an event coming up.
I'm
You have
actually
a number of events coming up.
I've
Okay.
spoken several times on this. I have an event in May for the U.S. Veterans Business Alliance down at Pechanga, San Diego.
Yeah.
I have another presentation that I'm doing for the California Health Underwriters Association up in Sacramento. I also have another one next week
Locally
at Evo Nexus in Irvine.
We've had those guys in here. Yeah, they have 2 places, one in San Diego and one here in Irvine. It's for
That's-
startups and stuff here. Yeah.
That's correct, and I'm giving that at Evo Nexus in Irvine on the 12th at 11 to 1 o'clock.
And we'll post that information too on the Facebook page for the Raad Life, and anybody and Lee's contact information. But yeah, I really urge you. It's like everything else. It's better to be more informed than less informed. And this is something that will impact everybody.
Well, the way I say it, Rod, is because you're a business, because you're not a human making business decisions on emotions, because you're a business, what you have to do is you have to evaluate and compare your cost of compliance versus your potential exposure. And let me give you a thumbnail. This will help all of your listeners to understand their exposure.
Please. Yeah.
Their exposure is this. It is my experience after 33 years. I've had a lot of these cases, dealt with a lot of these issues. Remember, this new law changed recently, but
there was
the
already...
Borrello law has been in effect for 30 years.
Yeah.
It's almost my whole career.
Yeah.
Not quite my whole career, almost. But I will tell you this. My thumbnail is that you have to expect an assessment of between 50 and 60% of what you've paid out annually to your miscategorized, or what they claim to be your misclassified 1099.
Yeah,
Let me give you an example. You usually don't have an audit the year after you make a change, right? So you'll have an audit in 3-4 years.
Right.
So you go through 4 years and you have paid $100,000 a year to a 1099 or multiple 1099s, which they believe you have misclassified. You will get a bill for, and I'm doing the easy number, not the 60%, but you will get a bill. If you've paid $100,000 a year, you paid $400 over 4 years, you'll get a bill from somewhere between $200,000 and $240,000. That does not include your lawyer's fees for having to deal with it. That does not include your accountant's fees for having to deal with the issue. And if the issue comes up in a weird manner, like, let me give you an example. Like a guy who's a 1099 contractor slips and falls at his premises or even your premises, but makes a claim at workers' comp. All right? Not only are you going to have all of those assessments, but you're going to end up with a very pissed off judge because you have an employee and you did not put away workers' comp insurance for them. Mm-hmm. Your problems first start then. So you really have to take a look at this. You have to evaluate your potential exposure of what you might have down the road. And if that potential exposure could put you out of business, then you absolutely must address compliance.
So I've got two questions. So does the factor of time spent have anything to do with it? Like you used to say that somebody would basically be full-time or part-time if they had certain hours. Okay, so does that apply? Is that a litmus test? Could it be 5 hours? It doesn't matter whether it's 5 hours or 4 hours or 40 hours that person has worked. It does not matter how much time they spent on working for you.
It does not matter. I will tell you how ludicrous it is.
Okay.
I have a client that I restructured them, but I have a client who's a party planner, and they do parties all over the state. So what they have to do everywhere they go, they have to get service people, they have to get musicians, they have to ride, all that stuff. Well, if that client hires these people for 2 weeks and then moves on to the next party in the next city or whatever, guess what those persons are going to do if they get hired for 2 weeks? They're going to file unemployment claims. My guys can't put up with that, all right? So we had to restructure them to figure out a way to get that done for them. Mm-hmm. And there are ways. And that's the thing. You can't just throw your hands up in the air. Look, if a lawyer says to you, look, I could think of a lot of things, but you're taking too much of a risk. It's just much better if this person were an employee. That should be a 30% of the time rare discussion.
So what do you say to somebody who basically instinctively in a situation like this, especially that now that we're sort of in tax season, says, I'm going to go to my attorney or my CPA to get clarification on this. Is that the right place for people to go for this information, or is it more likely that they should seek legal clarification?
I would go one of two places, okay? I'm a huge proponent of outside HR professionals, specialists, people who are specialized in California's highly complex labor laws. That should be your first level of inquiry, because those people charge at $150 an hour and are very schooled. If they're good, obviously, if they're good, they are highly schooled and can get you 90% of the way there with all of your employment issues. They also will be able to identify when you end up having to spend $650 or $750 an hour for a lawyer. They're able to identify when that is necessary. So I think is two levels that you can use. You can use a lawyer or a law firm to do all of your labor law review, analysis, and structure. Or what you can do is you can use an HR specialist to do all of your labor law structure and analysis, but all of the legal work and legal documentation and all of the issues that have to be handled are handled by the lawyers.
Yeah.
This way, the company makes the most efficient use of their professionals.
Okay.
That's the way I look at it.
Okay. So, and again, I'm asking that question because I don't know that people understand the complexity of this, to let alone figure out where to go for the information.
Let me tell you how
Yeah.
complex it is.
Yeah.
If you do not have a labor law specialist or a lawyer, I will almost guarantee you are violating some labor law. Almost guarantee you. So that's how complex it is. That's how much you have to handle. That's how much you have to know when you take on an employee or when you take on a 1099 to know that you're doing it right.
So now you've made the case, then the heck with it. I'm too small. I can't afford all this stuff. I'm just going to do without. I'm gonna err on the side of caution and not use any outside employees.
And what stops people from doing more? I mean, I know it's not the right thing to do, but literally paying more and more under the table.
It's illegal.
I understand. I understand that, but we all know. I mean, that's what I'm saying is this law is pushing a lot of people that don't have the financial means to actually do this to go underground.
No, I'll tell you what I've been hearing, and it makes me laugh. What I've been hearing a lot of people saying, a lot of people doing, is I'll take my chances. If they catch me, what I'll do is I'll end this business. I'll start a new business, same business, but I'll start a different company. I might even use the same damn 1099 contractors. Okay, I'll take my chances.
Yeah, right.
I'll take my you know what I have to say to that guy, Sparky?
Yeah.
There's a thing called responsible party liability, and that's personal liability, not corporate liability, and it's usually the owner of a small company, but can also be more than one person. It could be CEOs and CFOs, and that is the trust fund amounts, the withholdings that you were supposed to pay. You have stolen money from the state. That is a personal obligation. That includes the interest on that money. That includes a 30% penalty on that money. That's a personal obligation,
And
Sparky. You ain't getting away from it.
You can't bankrupt that. Yeah.
Oh, you can't bankruptcy that at all. That's non-dischargeable. Yeah.
So then to the other extreme, what Uber and Lyft and all those people are arguing is then we're going to leave the state because our business model is built around independent contractors. We can't survive if we have to pay people not just the wages but the benefits and all the minutia of lunches and all the other kind of things you got to be so careful about these days.
Times offs, all the breaks, all this stuff.
Well, Uber and Lyft are challenging the law, and other people are challenging the law. I will tell you that there's a lawsuit filed in the federal district court in Los Angeles. It's Uber and Postmates, but it's not just Uber and Postmates, but because they also had plaintiffs that were one of each of the 1099 contractors for Uber and Postmates. Their challenge to the law is a constitutional issue regarding a claim of arbitrary and capriciousness. I'm not going to go into it. I don't think it's got legs.
Truck drivers, there's a lawsuit.
Well, there's a lawsuit with truck drivers, but construction truck drivers have an exception. Look, I will tell you this. There are challenges to the law in court. I will tell you that Uber and Postmates have said that they have dedicated $90 million to a new California proposition. Now, I don't know what that proposition is, whether that is to overturn the old law
Or just
or
to
create
cover
new
that.
exceptions to that law. I don't know. I also know many industries that just stepped up their lobbying efforts to acquire twice as many exceptions as we have now. All right? So things are going to change. They're not going to stay stagnant. This is the initial shock we are feeling. I think Paul said it really well. You cannot stick your head in the sand. You cannot ignore this. If this comes back to bite you, it could be an existential threat to your company. At the very least, know what your exposure is and know what risks you are taking.
Yeah, take an informed risk.
And like Paul said, Uber and Lyft, everybody's talking, well, we'll just move out of the state and not do that. Number one, they make too much money in this state. This state is the 9th largest economy in the world. Okay? They'd lose too much money to do that. However, they might be smart and do well to shut down their services for a year and let people scream.
Right.
Pain. Okay?
Exactly.
That may cause
Exactly.
pain to people here.
Then basically
Absolutely.
it translates into the voting public.
Absolutely.
So let's talk
but
about
that's a
some-
calculated risk.
Let's talk about some of the exceptions. We've got a couple more minutes, Lee, but let's talk about some of the exceptions.
Give us some of the crazy ones.
Okay, wait, all right. You want to hear a crazy one?
I wanna hear a crazy
Commercial
one.
fishermen.
Commercial
All right?
fishermen.
They
yes.
must have an amazing lobby, my boys.
I'm just
two
thinking.
pages of exceptions.
I'm just thinking that these exceptions could be potential new business opportunities for people. Right?
Yeah, exactly. Listen, there's two types of exceptions. I roughly categorize them as two types of exceptions. There are what I call unconditional exceptions. All right? That's a misnomer because all exceptions, this is why the former law is still in play. All of the exceptions must satisfy the former law,
Right,
Borello.
right.
Okay? So that's first of all. Second of all, there's two types of exceptions. Unconditional exceptions. Those are generally the professions that are regulated. Give you an example. Doctors, lawyers, accountants, engineers, architects. Those are the people that, real estate brokers, real estate salespeople, licensed securities brokers, licensed insurance brokers. All of those are what I call an unconditional exception, meaning, for the most part, if you have a written contract and you satisfy, if you're a licensed professional in one of those professions, you're in the exception. You're all right. All right? There's a whole slew of what I call conditional exceptions. All right? Meaning, you could have this exception if you are a business to business, if it's truly a business to business, but you have to satisfy these 12 criteria.
Okay.
All right? You can have an exception for a professional services exception. All right? And in the professional service exception, there are 15 or so specific occupations in the professional services, but you have to prove 6 criteria in order to take one of those exceptions. And even the exceptions themselves, to give you an example, they're not as clear as one might think.
Okay.
Let me give you an exception that I think will be near and dear to Paul's heart.
Okay.
And that is the exception for fine artist.
Okay.
If you're going to read that exception literally, well, does that exception mean only a painter? Mm-hmm. Okay.
What does it mean as an artist?
And by the way, are you a fine artist if you don't do representational art and you just do abstract? Is that a fine artist? I don't know.
Right.
Okay. However,
I'm a radio artist.
you know something? I don't think you'll qualify there, but I'm going to talk about other things that I do believe do.
Okay.
Okay? So if you're a painter, if you're a sculptor, right? If you work in performance art, right? You're a dancer, you're an actor. I believe all of those qualify.
Okay.
All right? There are other types of exceptions, weird exceptions for tutors. All right? If you have a tutor, you can have an exception for a tutor if you're a referral agency. Meaning, if that tutor, there's all sorts of qualifications you have to meet, but if that tutor charges directly and all you're doing is the referral for that tutor and you get a little pay for the referral for the tutor, from the tutor,
What
obviously.
What happens to adjunct professors at colleges?
Part-time college professors. Huh?
Yeah.
They don't have a labor union. They don't have a lobbying group yet.
There are whole slews of industries that have problems. Let me show you one of the biggest industries, although it is dwindling, but one of the biggest industries in the state of California is the motion picture television industry, right?
Right.
And while there's an exception for a still photographer, in that still photographer exception, there's about 8 lines to tell you that a motion picture cameraman is not included.
Wow.
Okay? So all these guys, all these cameramen now working in Hollywood are going to have to be employees of somebody. All right, whether it's a production company,
And they're going to
whether
have to
it's
take a lunch
studio,
break in the middle of the shop and everything here.
Absolutely. And here's the situation. While they may not have paid their lobbyists enough, I will guarantee you they're paying their lobbyists now in order to get those people qualified.
Because they're on a shoot and location somewhere, and the actor's leaving, and the cameraman suddenly got to go take a lunch break.
I would be remiss if I don't ask this, because a lot of people that I know basically are either in my profession or in a distant profession. So I'm just going to ask, what about, like you mentioned, architects?
Yes.
Okay. What about like interior designers, graphic artists, people that are in those fields, okay, where they are basically light on employees and basically hire or bring on people as need be per project, or they bring them on for durations, as you know, like basically for capacity or whatever. How does that work? Are there any exemptions when it comes to that?
Everything. Because of this new law. Remember I told you the old law, we could use a single form contract for everything.
Yeah.
Everything stands alone. Everything is a case-by-case basis. Every contract has to look differently. To give you your example, there's an exception for a graphic artist or a graphic designer.
Okay.
Well, I interpret that to include a web designer. They call themselves web designers, but they're really graphic artists.
Correct.
Right?
Yeah.
So these broad exceptions, you need to have a professional look at it to see where we can fit them, or if we can. I will use the word wangle because it's a technical legal term.
Yeah, it's a legal term.
Yes, it's a technical legal term where we could wangle
away
that 1099 contractor to change the way they do things in order to qualify as a 1099, because most of the time that 1099 contractor wants to be a 1099 contractor and does not want to be an employee.
Right, they want the freedom of time. They got other things that are priorities. So
sounds like you need to get in touch with your friend Lee Goldberg here. How do people do that?
Yeah, how do people get hold of you?
Yes, I am of counsel at Ford and Dulio. I will give you.
That sounds like a freelance position to me.
I'm a lawyer. I'm exempt.
Of course. If there was one group I knew
immediately.
Exactly. You could contact us at Ford and Dulio. My email is
spell Ford and Dulio.
F-O-R-D.
F-O-R-D.
It's
Dulio is D-I-U-L-I-O.
Okay.
Shout out to Brendan and Chris.
Brendan and Chris. They're great guys. Listen, my email is lgoldberg, Goldberg, at forddulio.com. My phone number is 714-450-6830, but I'll do something else for you and your listeners.
Okay.
My cell phone is 949-395-4911. Do not call before 8 o'clock or after 8 o'clock.
And I mean it. Do not call him before 8 o'clock. He will bite your head off. No, but Lee is a great guy. I really wanted to share this. I think it's super critical and important for everybody to educate themselves. Honestly, know what your exposure is. I mean, at the very least, even if you're not going to do anything about it, know what your exposure is. Because if we pass on anything, is that there may be exemptions. You may not even be aware of the prior law that is on the books as it is. So you may already be in doo-doo, right, as it is. So take this opportunity, now that the pressure or the temperature has been raised, to actually find out a little bit more about where your exposure is. See what you can do. Obviously, this thing is going to clarify itself, and it's going to twist and turn and take different shapes as it becomes more and more clear. There's exemptions. Educate yourself. I don't think you can ever get enough information on something like this, because we work hard. I mean, you're doing something that either you have a very strong passion for, or that you're basically engaged in. Some of us have been doing it for a very long time. Don't put that all at risk just because you don't want to take the time to find out. Take the time to find out. We'll share Lee's information on the Facebook page. He's been very generous in giving his personal cell phone number. I'm not going to put that on the Facebook page, but you'll have to listen to the episode to get that, right? But also look for further information that we will also be sharing on this over the next few weeks. And also I will post about his upcoming events. This is something, if you're in California, If you are a business owner, I don't know how you can bury your head in the sand. Stop being an ostrich. Get your head out of the sand. Pay attention to this. Lee is available. Thank you so much, Lee, for being here today.
You're welcome. It's my pleasure.
I really appreciate it.
Thank you, Rod. Thank you, Paul.
You have been listening to the Raad Life Radio Show with your host and age explorer, Rod Gantoos, brought to you on the one and only octalkradio.net. Join us again next week as we continue our journey of discovery into life's challenges, opportunities, options, and all the latest and greatest things that come with getting older.